Good morning, viewers. This is the YouTube channel Lex Consilium Foundation. I am Major General Neelendra Kumar. Now, you are aware that on 20th November, something very extraordinary, a decision came. This was a development in the judicial circle on the constitutional stage of the country, and I am referring to the 20th November judgment of the Supreme Court, five judges bench that was headed by Chief Justice B.R. Gawai, Justice Suryakant, Vikram Nath, P.S. Narasimhan, and A.S. Chandurkar. And the matter before the court was the culmination of the presidential reference that was sent to them by the President of India, uh, and Draupadi Murmurji, and the decision came. I'm not very sure about the judicial parlance, whether it should be called a judgment when a reference is sent to the Supreme Court. Well, that was the culmination. And what are the implications of this judgment? That seems to go contrary to an earlier decision of April that was given by Justice Padiwala and R. Mahadevan. For this, we have here a very eminent expert jurist in Justice Madan Lokur. Now, Justice Madan Lokur, as you know, was a judge of the Supreme Court from 2012 to 18. Before that, he had been the Chief Justice of Andhra Pradesh at Guwahati High Court, and prior to that, he had been a judge of Delhi High Court and an advocate on record, a very distinguished judge who's very, very active. When I called him up yesterday for this, his whole week is jam packed. He has a function, a lecture to give tomorrow evening. Perhaps on POXO, he was with the Galgotia University yesterday. So I will come straight to the point. How do you view this development of 20th November in relation to the decision that has been given by the five judges bench? Justice Lokur, please.
Yeah, you see the advisory opinion that was given, which you referred to on 20th of November,
Yes.
was in the context of a judgment delivered earlier by two judges of the Supreme Court in a case filed by the state of Tamil Nadu. Right now, in the earlier decision, what the Supreme Court said was that essentially, they said that the governor of a state cannot sit over bills that have been passed by the state legislature. There were instances where the governor was taking no action on the bills for 1 year, in some cases for 2 years. So the Supreme Court said that there has to be a timeline for this, and they said that I think if I remember correctly, they said the timeline should be 3 months for them
Yes.
for the governor to take a decision. Now the President of India can approach the Supreme Court for advice on a constitutional issue. So the president approached the Supreme Court with a set of questions, saying that please advise me on what is the correct constitutional position. And those questions were answered by the Supreme Court in the advisory opinion. Now, I went through the advisory opinion given by the Supreme Court, and it reads in some places, as if it's an appeal against the earlier judgment in the case of the state of Tamil Nadu. I would imagine, that being the looking at the context in which the advisory opinion was sought, I'm not surprised that it reads like, in some portions, like an appeal against that. But I think the Supreme Court should have steered away from that appellate sort of a view and advised the president on the correct. Now, coming to the essence,
Yes.
which is really the idea about whether the governor can sit over bills. The Supreme Court has not has advised the president that the governor cannot sit over bills for an indefinite period, right, or for a prolonged period. But what is an indefinite period? What is a prolonged period? What is an unreasonably long period? That the Supreme Court has not answered, and I suppose it will have to be answered on a case to case basis, which is a problem because then it means that governors can continue to sit over bills as they have been doing in some cases, and wait for the state government or some people in the state to say that listen, we think that you've been sitting over bills for an indefinite period. So this is inviting, in a sense, or condoning the actions or the inactions of the governor. I think there definitely is required far more clarity. The second thing, which I think the Supreme Court should have taken into consideration was that how often is this happening? I remember reading in the Times of India about bills that are pending the approval of the governor of some states and even the president of India. Right? Now, in the case of West Bengal, for example, I remember reading that bills were pending for 5, 6 years. There is supposed to be one bill which is pending with the president of India for about 2 years. So, what is an indefinite period? I mean, is 2 years not an indefinite period? Where do you draw the line? Now, in several parts of the judgment, the Supreme Court has referred to something called a 6 month period
Yes.
for the governor to take a decision after the case is sent by the
Reference. Yes.
yeah. So I think the Supreme Court should have said, well, the Constitution recognizes 6 months as a time limit. So yeah, that should be the time limit. But that does not mean that in every case, the governor will say, all right, this is a time limit of 6 months, so let me hang around for 6 months and see what is to be done. After all, bills are passed by the state legislature because of the need to pass a law, right? And that law has been passed, obviously, in public interest, unless the courts hold otherwise.
In the process laid down under the Constitution, the law has been,
Right.
yes, the bill has been passed.
Correct. So why should the governor unnecessarily, prolong taking an action on the bill? If the bill is perfectly fine, give assent. If there is a problem, return to the legislature. If there is a constitutional issue that is involved, refer it to the president. I mean, this shouldn't take 6 months.
Now, Justice Lokur, I would request for your views from another angle. Now,
Yeah.
this decision talks about discretion.
Yes.
Now, what does the discretion means? Does it mean the whims and fancies? Because one view of the matter is that the office of the governor is sort of not, the governor is not elected. He is appointed. So, to whom is he answerable? Can he, at his discretion, do what is called in common parlance the pocket veto, or without any reason sit over it? There's got to be some reason, there should be some justification, something that's puzzling his mind, and he needs to deliberate over it. Would you like
Yes.
to dwell on that aspect also?
Yes. Now, you see, discretion is in the context of the power of the governor to deal with the bill,
Yes.
right? So, one is assent. Okay, in his discretion, he says that yes, I want to assent to the bill, which has been passed by the state legislature. So the question of exercise of discretion in saying yes, I agree, that question I think is doesn't arise. The second is withholding the bill. That in the advisory opinion, they said that withholding doesn't mean a pocket veto, that you don't take a decision.
Yes.
Reading the withholding power in the context of the first proviso, the Supreme Court says that when you withhold a bill, you have to send it back to the state legislature for reconsideration.
Yes.
All right. Now, when he sends it back, when the governor sends it back to the state legislature, it's not that you send it to me, so I'm sending it back to you. He has to explain why he's sending it back. What is his objection? So he has to give a reason. I mean, he just can't say, today I feel like sending it back, so let me send it back. That's not discretion.
Right.
So he has to say that, well, I feel that this provision is not correct, or this provision is a little vague, or something, whatever it is, And it is for this reason that I am sending it back to you. And the state legislature will consider the view of the governor and then say that, yes, we agree that there is some problem over here, so we modify the section. Or they say that, yeah, we don't think what you have said is correct, so we send it back to you for your assent. So there the discretion really is hedged in by reason. To send it back with some reason, not just to send it back. The third aspect is to send it to the president, right? Reserve it for the consideration of the president. There again, the discretion is narrowed. Does it violate some law that has been passed by the parliament? Does it impinge upon the jurisdiction of the High Court, for example? Or is it otherwise unconstitutional? Maybe wrong. I mean, he doesn't have to say it is unconstitutional, but he feels that there is some problem. Then the ball shifts to the president. Okay, so one would expect that the president would act in accordance with the constitution and look into it. So here again, the discretion of the governor is hedged in. That I can't send it to the president. The governor says I can't send it to the president because I feel like sending it to the president. He has to tell the president why is he sending it. So to that extent, reasons come in. Of course, this is not specifically mentioned in the constitution, but I think it is by necessary implication one has to read reason into the provisions of the constitution.
And when a bill has been passed by the state legislature, so that is the legislative function in that view that has been done. Now, this with the position that the governor will act on the advice of the cabinet. Now, how do you read that?
Yeah, I don't think the passage of bills is on the advice of the cabinet. The cabinet or the cabinet essentially puts the bill before the state legislature, and the state legislature passes the bill. I'm not sure how the procedure works. That's I have absolutely no idea, and the judgment also, advisory opinion also does not mention it. It goes from the state legislature to the governor. Whether it goes through the chief minister or whether it goes through the speaker, I don't know. But that is a decision of the state legislature. That's not the decision of the cabinet.
What I was pointing out is that the state legislature have done their job.
Yes.
With regard to the making of that bill, passage of that bill that has been passed by the state legislature.
Right.
Now they send it to the governor.
Yes.
Now, with regard to the options available to the governor, does the cabinet that come into the play at that stage?
No, the cabinet has no role after that.
Okay.
The bill has been passed by the state legislature and has gone to the governor.
Yes.
The governor has before him a bill passed by the state legislature.
Now, thereafter, if it is the discretion of the governor does it refer to, or does it point out, or does it imply the subjective discretion?
Well, it has to be, I would say,
Then where is the rule of law?
yeah. You see, it would have to be objective in the sense that, I'm not sure whether this subjective satisfaction or subjective discretion or objective satisfaction would really come into play because the powers of the governor are hedged in by the constitutional provision, Article 200. When it's a question of assent, it means he's not disagreeing with the state legislature. All right? It doesn't matter whether he's satisfied subjectively or whether he's satisfied objectively. The fact is he's satisfied and he's agreeing with the, and he signs and says, yes, I convert this bill to an act. Now, when he is sending it back to the state legislature for reconsideration, it has to be objective. It can't be subjective. It can't be that, I think it requires reconsideration. I won't tell you why it requires reconsideration. What is the state legislature going to do if it doesn't know why it has been sent back? So that has to be an objective assessment.
And propriety of that,
Yes.
sufficiency of that, is it justiciable?
Not necessarily. Not necessarily. Because why? It's going back to the state legislature. The state legislature can look into it.
Okay.
Why go to a court to say that, well, state legislature should not look into it? I mean, it doesn't make any sense.
But does that mean that this sort of a thing is beyond the judicial scrutiny or judicial review?
The judiciary, I don't think, comes into play at that stage.
Okay.
Okay, and the Supreme Court has made it very clear that when you have a bill, you can't challenge a bill before it becomes an act.
Yes.
When it becomes an act, you challenge it in the court, the High Court or the Supreme Court, as the case may be.
Yes. Now, linked with this is that this advisory opinion rendered by the Supreme Court, 5 judges bench, how does it stand with the vis-a-vis the April decision of the Supreme Court, 2 judges bench?
Yes, that is very debatable because the decision given by the 2 judges bench is the law laid down by the Supreme Court, whereas the advisory opinion is an opinion given by the Supreme Court,
Yes.
which should ordinarily be accepted or acted upon, if not accepted, but acted upon by the president. So here you have, a bit of a dichotomy. You have the advisory opinion of the Supreme Court telling the president that this is the way the Constitution should be interpreted, right, or should be understood. And on the other hand, you have the Supreme Court saying that this is the way the Constitution is interpreted. You see, so there is a bit of a dichotomy, and ultimately, I think the president will have to decide what to do. Maybe, I don't know, I'm just speculating. Maybe a review petition can be filed against that 2 judge.
The review petition with regard to the 2 judges bench, or
Yes. To the 2 judges bench.
I would also seek your views.
Yes.
It has been said at some quarters that by not agreeing to that 3 months timeline, and yet saying that in certain situations, in extraordinary situations, if the governor is sitting over a bill, the Supreme Court would not be immune from going into the matter. Now, this has been said that this is indirectly expending, the Supreme Court indirectly expending its own role.
I don't know. You see, when the Supreme Court says that the governor cannot sit on a bill indefinitely, right? Inaction is not a part of the constitutional function of the governor. How do you come to the conclusion that the governor is sitting over a bill indefinitely? Okay, somebody has to take a call on that. And I don't see anybody taking a call on that except the president, because the president appoints the governor. The president should, tell the governor that, listen, what are you doing? You're not taking any action on bills that have been sent to you. All right. It could also be the state legislature itself, saying that, listen, we have no confidence on the governor. The governor is just busy sitting over bills that we are passing. We have no confidence over him. And, maybe request the president to recall the governor, appoint somebody else. You see, so these are, and of course, the third option is there to go to the Supreme Court and say that, listen, this person is not taking a decision. 6 months have gone by, 8 months have gone by, you know. So there are these options
So
that are.
you indicated three options. In one case, it was the president who's the appointing authority. Then it was the state legislature, which
Yeah.
in a way is aggrieved. Or the third thing is then Supreme Court is approached. Now,
Yes.
since one of the options is Supreme Court approach, and here it is Supreme Court has not agreed with that 3 months timeline given. In that context, if you see the two things together, would you agree that it is expanding the role or the work of the Supreme Court?
Not really, because the 3 month timeline, of course, is there. That's why perhaps a review petition may have to be filed.
Yes.
But if you go by a 3 month timeline, assuming it's there, right? It exists, and the governor sits over a bill for more than 3 months. Somebody may come to the Supreme Court or the state government or whoever it is may come to the Supreme Court and say that, listen, that 3 month timeline is over. The governor is sitting over the bill indefinitely. Please do something about it. The Supreme Court will then take a call to see whether it is indefinite.
So now may I ask you, how do you see that the way ahead? I'll leave it at that.
Yeah, well, the way ahead is really for the president to take a call. That we have reached a situation like this where the governor is, within inverted commas, guilty of inaction. Why should this have happened at all? I mean, is the governor appointed to be hostile to the state government? Was that the intention of the president? Certainly not. So I think the when we talk about constitutional morality, where is that? The governor has to keep constitutional morality in mind. The 130th Constitution Amendment Bill talks about constitutional morality. Now, is it anybody's contention that the governor is not bound by constitutional morality? So the fact that we have come to this situation is very sad, and I think the president should take the reins in her hand and, if necessary, discipline the governors.
Yes, because after all, this whole situation is not merely an academic discussion.
Yeah.
This is based on certain facts and circumstances that exist, which Supreme Court, I'm sure, would be aware. Now, do
Yes.
you see this as a situation of constitutional impasse?
No, not really. Impasse in what sense?
Impasse in the sense that we have number of states where the non-BJP government is there. And this Tamil Nadu or Kerala are perhaps not alone. This situation, the governor sitting over the bills taking time, is not peculiar or not confined to a particular state. Now, in that view of the matter, I was seeking your views that would you see this as beginning of a constitutional impasse?
Yeah, you see, there, I think the president, as the appointing authority of the governor, should see where are we going. Did the framers of the Constitution, did the Constituent Assembly visualize a situation like this? The Dr. Ambedkar said in his concluding address to the Constituent Assembly, and that was echoed also by Dr. Rajendra Prasad the next day, that we have given you a good constitution. But even a good constitution, if the leaders are not good, what's the use of a good constitution?
Right. In
Right?
fact, it was commented that in certain situations, the governor or the president even if it was explained that a death warrant against themselves is put up, they have very little option as but to agree with the Council of Ministers, otherwise one has to resign. Well, I would not seek your views on that, but would you agree? Some jurists have they say that they have been reminded of ADM Jabalpur at this point of time.
I'm not too sure. I mean, the context is completely different. I mean, ADM Jabalpur was for personal liberty.
Yes.
So yeah.
Thank you very much, Justice Lokur.
Okay.
Your articulation, I'm sure, will be helpful and would inform a large portion of the audience. Thanks for your time.
Thank you. Thank
Thank
you.
you.